Gary Wall here, and this is Bridging the Week for July 28th to August 1st, and today is August 4th, 2014. Good morning! Fitting for the dog days of August in the United States, the U.S. Commodity Futures Trading Commission demonstrated it has both a meaningful bark and bite in settling two high-profile enforcement actions against alleged manipulators of crude oil futures and an alleged falsifier of internal trading records of his employer. On the other hand, industry participants roundly criticized CFTC position limit proposed rules in the final days of a reopened comment period. We have a lot of different articles to cover this week, so let's get started. 5 defendants agreed to settle a CFTC enforcement action involving their alleged manipulation and attempted manipulation of crude oil futures from late 2007 through April 2008 by consenting to payment of a $13 million civil penalty. The defendants are Parnon Energy, Arcadia Petroleum, Arcadia Energy Suisse, James Dyer, and Nicholas Wildgoose. The CFTC had alleged that the defendants engaged in a manipulative strategy by accumulating a sufficient quantity of physical crude oil that satisfied relevant delivery requirements of crude oil futures contracts traded on the New York Mercantile Exchange and ICE Futures Europe in order to, quote-unquote, dominate and control the relevant supply, although they had no business need. At the same time, the defendants purchased long futures positions on the relevant NYMEX and ICE crude oil contracts to help drive up the value of their physical assets. Later, claimed the CFTC, the defendants sold short the same futures contracts at, quote-unquote, artificially high prices and subsequently sold off their physical positions unexpectedly. This drove down crude oil futures prices dramatically, thus increasing the value of defendants' short futures positions. Separately, the CFTC received a flurry of letters during the last few days of a reopened comment period in response to its fall 2013 proposals to establish position limits for 28 exempt and agricultural futures and option contracts and equivalent physical commodity swaps, as well as to amend its aggregation policy. Overall, the Commission received 270 letters, most of which were critical of its proposals. In general, writers requested that the Commission expand the definition of bona fide hedging, provide a more efficient means to address requests for non-enumerated hedging exemptions, and relax its aggregation proposal. John Brooks, a former director and trader for Citgroup, Inc., agreed to settle charges by the CFTC that he cheated and defrauded his employer from November 2010 through October 2011 when he concealed trading losses by mismarking and inflating the value of certain future contracts in his trading account. In connection with the settlement, Mr. Brooks agreed to pay a fine of $500,000 and be barred forever from registering with the CFTC in any capacity, among other penalties. The CFTC had filed an enforcement action against Mr. Brooks in September 2013 after Citgroup and an affiliate sustained trading losses in excess of $40 million as a result of his alleged wrongful conduct. Mr. Brooks did not admit or deny any of the CFTC allegations in agreeing to the settlement. The Board of Governors of the Federal Reserve System and the Board of Directors of the Federal Deposit Insurance Corporation criticized the resolution and recovery plans of 11 banking organizations under their joint oversight. Each of the organizations was required under the Dodd-Frank Act to submit to these U.S. regulators resolution plans because they maintain consolidated assets of at least $50 billion. Common features of the organization's deficiencies included relying on assumptions regarding, quote, the likely behavior of customers, counterparties, investors, central clearing facilities, and regulators, end of quote, the regulators considered unrealistic or insufficiently supported, and failing to propose structural changes or amendments to practices to augment prospects for orderly resolution. Each of the 11 institutions is required by the regulators to show they are making sufficient progress to address the deficiencies in annual plans they must submit by July 1, 2015. The CME Group has proposed amendments to its rules to clarify that no netting generally may occur by an owner in connection with concurrent long and short positions in physically delivered physical contracts once spot month position limits become applicable and all days afterwards. During such time, concurrent long and short positions may only be offset in the marketplace, except for positions resulting from bona fide clerical or operational errors. These amendments will be effective August 19th, pending the expiration of CFTC regulatory review periods. The European Securities and Market Authority adopted so-called guidelines and recommendations for European regulators to help ensure that European-based clearinghouses comply with the principles of financial market infrastructure adopted in April 2012 by the Committee on Payment and Settlement Systems for the Bank of International Settlements and the International Organization of Securities Commissions. At this time, however, the sole guideline adopted by ESMA is that regulators, when authorizing and supervising clearinghouses within their territory, should ensure that they comply with the PFMIs and operate in a manner that is consistent with them. Wait, just one guideline and call them guidelines? That's strange. The Federal Energy Regulatory Commission has issued notice of a non-public investigation against a private investor energy trading firm, Powhatan Energy Fund, LLC, claiming it engaged in wash trades to collect over $11.5 million in power market rebates between June 1st and August 3rd, 2010. The alleged wrongful trading involves spreads in so-called, quote-unquote, up-to-congestion trading in the PJM Interconnection LLC Regional Transmission Organization. FERC apparently has been reviewing this matter since at least 2010, prompting Powhatan to maintain an internet page that explains its defenses, including a video summary of Powhatan's position and video testimonials of various experts. The link to this internet page is on my website. It's surreal. Check it out. And finally, Judge Jed Rakoff of the U.S. District Court in New York City approved a $285 million settlement between the SEC and Citgroup Global Markets related to the agency's 2011 lawsuit against the bank over its structure and sale of a fund beginning in 2007, mostly secured by subprime securities. Judge Rakoff previously had declined to approve the settlement, but a court of appeals subsequently ruled that he had misapplied applicable legal standards in doing so. As his rationale for approving the settlement at this time, Judge Rakoff noted, quote, "They who must be obeyed have spoken, and this court's duty is to faithfully fulfill their mandate. The Court of Appeals has now fixed the menu, leaving this court with nothing but sour grapes." End of quote. So poetic. Well, that's it for this week's Bridging the Week. As always, there is more information in each article and more articles on the article version of Bridging the Week on the Gary DeWall and Associates website. Until next week, this is Gary DeWall. Have a great week, and ciao!